Yeah, Mr. Joshua, can you use hands-free, please? And can you share your slides?
Oh, hands-free.
Yes. Are you using slides?
Eh, It will be somewhat cumbersome to use slides since there are about 8, 9 slides and I can't run through all of them.
Okay. So what do you?
Okay. I also wanted to confirm if you can hear me. Is my audio good?
Yes, yes, it's good now.
All right, thank you. Yeah, so we would commence right now. Is there an introduction that is to be done before I commence?
You can introduce yourself, sir, and start immediately.
All right, all right, all right. Good morning. My name is Joshua Yonda, and this is ICANN Online Tutors. We are starting our review on business law. We'll be taking all the classes. At the end of the class, if you have any questions, please do well to ask. So we proceed immediately. We start with company law. So we stated, or rather we should know that at the end of this class, you should be able to define a company and know the types of companies that exist and their different features. So what is a company? A company is an entity. A company is a business entity formed by either one person or an association of persons carrying on business with a distinct legal personality. So what does this mean? Formerly under the CAMA 1990, which was in LFA in 2004, a company has to be an association of business between two persons. However, under CAMA 2020, which repealed CAMA 1990, one person can form a business. One person can form a company, rather. So what is a company? A company is a business entity formed by either one person or an association of persons carrying on business with a distinct legal personality. The operative word is a distinct legal personality. So what does a distinct legal personality mean? It means the company is different from its founders. So you must have that definition up your head. A company is a business entity formed by one or an association of other persons carrying on business with a distinct legal personality. So that should be that for that. So what are the salient features of a company? One, a company has distinct legal personality. Let us not forget that. Two, a company has definite objects. What do we mean by definite objects? Each company must have specific business objects it does. So each company must have specific objects. By object, we mean business category. So each company must have definite objects, specific business category under which it falls. And lastly, a company can be formed by one person or an association of persons. So distinction between CAMA 1990 and CAMA 2020 on number of persons that can form a company. We indicated here that just as I told you, one person can now incorporate a company under CAMA 2020 as opposed to the extant position under CAMA 1990. So one person can form a company. And the effect of this is far-reaching. I have explained to us what the doctrine of distinct legal personality is. Distinct legal personality, as I said, I don't need to go over it, means a company is different from its members and its owners. And the act of the company, right, or rather the persons who form part of the company will ordinarily not be liable for the acts done by the company. The doctrine of distinct legal personality is such that the act of the company is different from the act of individuals and none will be liable for the act of the other. This is a principle that is laid down in the case of Salomon versus Salomon. If you are stating on this principle, you must know this case. Salomon is spelled Salomon. The case of Solomon versus Solomon it is called judicial precedent. It's the judicial precedent for this principle, to the effect that a company is a distinct legal personality. A company is a distinct legal personality. So we move on, please. I need you to be very attentive. Types of companies. We have the private company, we have the public company, we have the company limited by shares, we have the company limited by guarantee, we have the unlimited liability company. Now, what is a private company? A private company is a company that restricts its transfer of shares and limits its members to 50. Please let us listen. We have a private company, a public company, a company limited by shares, an unlimited company, a company limited by guarantee, and incorporated trustees. I'll now go to explaining. So what is a private company? Okay, I think it's better stating it this way. A private company is a company that has a minimum number of 1, a maximum number of 50, right? So the lowest number of persons that the private company can have is 1. The highest it can have of membership is 50. 2, the name of a private company LTD. I will suppose that you would have seen it, where you see companies that would have LTD, right? That means they are LTD. The minimum share count. Now, each company minimum has to be have a fuller understanding, right? Each company has a limited share capital. A share is a unit of ownership of a company. Now, each company has a minimum, as the name implies, minimum share capital. That is the lowest capital requirement of a company. So the lowest capital requirement of a private company is 10,000 naira, which 25% must have been subscribed to. By subscribed to, this is what we mean. A company has shares. Assuming the shares, the minimum is 10,000 and they went to the minimum, which is 10,000 naira. 25% of 10,000 must have been given out to members of the company, where they must have subscribed to it. I hope you understand that. So that is for a private company. And also the public is restricted from subscribing to the shares of a private company or depositing money with it. So that is that for a private company. As we stated, minimum membership 1, maximum membership 50. Authorized share capital is 10,000, of which 25% must have been subscribed to. It ends with LTD, and the public is restricted from ownership or purchase of shares in a private company. So we move on quickly to public company because we have a lot of ground to cover. A public company has the following attributes. 1, minimum membership of 2, and unlimited maximum membership. So a difference between a private company and a public company is a private company has a maximum membership of 50, while a public company has an unlimited membership. 2, the name of a public company ends with PLC, right? So remember, private company held to the public company PLC. 3, a public company has the capacity to invite members to subscribe to shares. 4, the minimum share capital of a public company is 500,000. Remember, a private company was 10,000, of which 25% must have been subscribed to. A public company is 500,000, of which 25% also must have been subscribed to. And 5, a public company must hold statutory meetings within 6 months of its incorporation. We're eventually going to go into the meetings, but then there's a meeting called a statutory meeting, and a public company must hold a statutory meeting within 6 months having of its incorporation. So we go to company limited by shares. Remember, there are different kinds of companies. So private, public is what we have discussed. So we move on to company limited by shares. A company limited by shares are companies where the liability of the shareholders for the debt is limited to the amount paid on their shares. How can I explain this? Okay. A company limited by shares is a company simple. If you are asked to explain what a company limited by shares is, simple and straightforward. A company limited by shares is a company whose members have limited liability. I would explain that. But if you are to just explain it in simple words where it will be concise, instead of stating a lot of story, a company limited by shares is a company whose memberships or whose members have unlimited, whose members have limited liability. So what does limited liability mean? Remember, we stated that members of a company subscribe to shares. Now, when members of a company subscribe to shares, they are to pay up the shares allotted and subscribed to. When they don't pay up, if the company has any liability, the liability is limited to what they have left unpaid. For example, I subscribe to GT Bank shares in the range of 500,000 units of shares, 1 naira each, which is 500,000 naira. Now, I do not pay up on those shares. GT Bank has a financial issue and is going under. My liability to GT Bank as a shareholder is my 500,000 unpaid units of shares. So a company limited by shares is a company whose membership are limited, or is a company by shares is a company whose membership have limited liability. Whose members have limited liability. Just 5 words. Company whose members have limited liability. A company limited by guarantee. First of all, let me explain what it is. The company is a non-for-profit company, right? So a private company runs for profit. A public company runs for profit. A limited company, a company limited by shares, run for profit. An unlimited company runs for profit. But a company limited by guarantee does not operate for profit. Do you understand? So a company limited by guarantee is a non-for-profit, that is, it does not operate for profit, and it has a memorandum. In that memorandum, the objects of a public by guarantee are stated, whether it's for art, whether it's for science, whether it's for promotion of religion, whether it's for sports, whether it's for charity, whether it's for research. The objects are stated, and in the memorandum, each member has an amount subscribed to. Now, for example, Kehinde and Joshua decided to incorporate a company limited by guarantee. They will have a memorandum, and in the memorandum, they will state that in the event that this company goes under, Joshua is going to be liable to the extent of 10,000 naira. Kehinde is going to be liable to the extent of 10,000 naira. So they indicate in their memorandum the extent of their liability. So they are not registered with shares. Their company name ends with LTD GTY, meaning limited by guarantee. So what I've said, the company limited by guarantee is a non-for-profit company or organization. Their objects are stated in the memorandum. The members are limited to the amount subscribed to in the guarantee, and it ends with the GTE. Now, limited company. Limited is a company whose is unlimited. I mean, whose liability is unlimited. Because that shall obligations or liability, the word connotation implies unlimited liability. We move on quickly. So that is that for types of a company, right? I believe if we have understanding, sector can if you can hear me, can Hello, can you hear me? All right, so yes, let's proceed. So apologies, we had a bit of a technical glitch. Yes, so um, we just finished dealing with a company. I'll quickly do a recap of it. One, a company is a business entity formed by one person or an association of two of persons with a separate legal personality and the intention to do business. In fact, you can remove the intention to do business because we say a company is a business entity. So in order to give concise definitions, a company is a business entity formed by one person or an association of persons with distinct legal personality. Full stop. Types of companies: private company, public company, unlimited company, company limited by shares, company limited by guarantee. Private company is a company that restricts the subscription of the shares by the public, has a minimum of one member and maximum of 50 members. It ends with LTD. A public company is a company that does not restrict the subscription of shares by the public to its shares, has a minimum of one member and maximum of 50 members. It ends with PLC. It must hold statutory meeting within 6 months of its incorporation. An unlimited company is a company to which the membership, or rather the members of the company, have unlimited liability. we explained that this means that the liability of the members of the company are not limited, and a liability had by the company will affect all or every of the assets of the member. We stated that a company limited by shares, remember there's an unlimited company. Limited by shares is a company to which the members have limited liability, and a company limited by guarantee is a company to which the liability of the members of the company is limited to the amount subscribed to in the memorandum of guarantee. We stated that a company limited by guarantee has LTD/GTE at the back of it. A company limited by guarantee is a non-for-profit company that to which the objects of the company are as indicated in its memorandum. We stated that an example of the objects of a company limited by guarantee is arts, science, religion, research, and other objects in like manner. So we move on to the organogram. We'll be moving slowly to the organogram of a company. Now we'll go to the concept of the lifting of the veil of incorporation. Now, a company is a separate legal entity. We stated that as seen in the case of Solomon versus Solomon. However, there are instances where the fact that the company is a distinct legal personality can be used to perpetrate fraud, can be used to do something illegal. For example, cannabis, cultivation and sale of cannabis is restricted under Nigerian law. Assuming there was no exception to the concept of the lifting of the veil, I can go and form a company, Cannabis Nigeria Limited, and use it to cultivate and sell cannabis because I am a distinct legal personality and my liability does not extend, or rather the liability of a company does not extend to me. So the fact that a company could have been used as a machine or a vehicle for fraud brought about the concept of the lifting of the veil of incorporation. Now, what does the lifting of the veil of incorporation means? As the word implies, lift the veil. This is a doctrine that connotes the removing of the separate legal personality of a company to see the human officers of the company. This is removing the cloak, the clothes, the garment of incorporation to see those running the company. Now, the veil of a company will not be removed at all instances. The veil of incorporation will be removed in some instances. I will give you 5 instances. 1, where the company is used to perpetrate fraud. Say, for example, all of these Ponzi schemes. You will see that they have companies, but then law enforcement agencies and people are suing them directly. Why can they do this? Because their company has been used to perpetrate fraud. 2, a company formed for illegal purposes. Where a company was formed for illegal purposes or carries on illegal purposes, for example, the cannabis example I gave to you, the veil of the company will be lifted. 3, where the activities of the company goes against public policy. Now, say for example, I incorporate a company and I am sponsoring publications or media broadcasts that go against the territorial integrity of Nigeria. The veil of the company can be lifted. 3, when I engage in acts detrimental to public interest. Now, if I incorporate a company that is supposed to clear sewage and I am littering the sewage all over the public places, the veil of the company can be lifted. And 5, where the activities of the company is completely ultra-virus. What does ultra-virus mean? Outside of its powers. I incorporate a company for the purpose of supplying building materials, and then I start taking up the work of a structural engineer. The activity of that company is ultra-virus, without power, without necessary authority, without required authority, and the veil of the company can be lifted. I think I've dwelled too much on this principle, and I do hope you understand it fine. So, I move on. Now, formally, please let's listen carefully because this list is quite technical. Remember, we stated that a company can have one member. Yes. However, that is qualified. But for this level, I'm not going to go into this because I feel this is a bit too technical. I'm not going to go into this. But it also is also one of the ways that the members, that the veil of the company can be lifted. Now, if a company is a company that must have, there are some companies that must have two members, but that can be a bit confusing. Right? That can be a bit confusing. So I would not go into that, but not for the purposes of your exams, just for the purposes of education. A company can have one, it has a minimum membership of one member, and for a private company, maximum 50, for a public unlimited membership. However, there are companies that can benefit from this one membership principle. For a company to benefit from this one membership principle, it must be a small company. A small company by CAMA 2020 is a company whose turnover is less than 100 million. If a company's turnover is more than 100 million, it cannot have less than two members. Where a company is not a small company and has less than two members, the veil of the company can be lifted. Where a company is not a small company and its directors is reduced to below two, the veil of the company can, and operated business for 60 days, the veil of the company can be removed. Now, what other instances can the veil of the company be removed? Where investigators are appointed to look into the affairs of a company, where dividends is paid out of capital, right? Dividends should not be paid out of capital. Dividends should be paid out of profit. But where dividend is paid out of capital, the veil of the company is removed and deduction of separate legal personality will not apply. Also, to determine a company's taxable obligations, the veil of a company can be removed. So that is that for lifting of the veil of incorporation. We move on to a pre-incorporation contract. Now, what's a pre-incorporation contract? A pre-incorporation contract is a contract entered into by a promoter of a company on behalf of a proposed company that is not yet incorporated. Now, Kehinde wants to incorporate a clothing line company. However, Kehinde has not yet incorporated this company, all right? And she wants to enter into an agreement with a clothing line in China for supply of fabrics. The Chinese really need to enter into that agreement or they'll move on to another clothing line business. Kehinde is of the view that she really needs to have this agreement with this Chinese clothing line, not minding that she has not incorporated Kehinde Clothing Line Nigeria Limited. Kehinde can enter into a contract, a pre-incorporation contract, on behalf of the proposed company and the other party, where Kehinde will acquire property or acquire rights or acquire obligations on behalf of the proposed company, being Kehinde Clothing Line Nigeria Limited, with the other party, being the Chinese clothing line. I gave the example because I want us to really understand it. So this is a contract entered into by a promoter of a proposed company which has not been incorporated. Now, we'll move on to the legality or validity or bindingness of a pre-incorporation contract. Now, I will not go into the formal position. Okay, I should go into the formal position because this is contained under ICANN syllabus. Now, under CAMA 1990, right? Rather, before CAMA 1990, a company could not ratify a pre-incorporation contract. However, under CAMA 1990 and CAMA 2020, that is a new position, is that where a promoter has entered into a pre-incorporation contract on behalf of a company, the pre-incorporation contract is not binding on the company until the company ratifies it. What do we mean by ratify? Accept it, right? Until the company approves it. When the company approves it, then the pre-incorporation contract becomes binding on the company. The reason behind it is this: the company was not in existence when the contract was formed. So it will be wrong to impose rights, duties, and obligations on a company when the company has not been formed. However, if you have purportedly incorporated it on behalf of the company, when the company comes into being, it is just right that the company can either choose to ratify it or rescind it. When the company ratifies it, then it becomes binding on the company. Yes. So yes, that is that for a pre-incorporation contract. Now, what happens when the company does not ratify a pre-incorporation contract? When the company does not ratify a pre-incorporation contract, the promoter of the company becomes liable for that contract. So the promoter of the company becomes liable for that contract. We move on quickly, please. Now, what is the procedure for the formation of a company? 1. Any one or more persons may form a company in compliance with the Companies and Allied Matters Act 2020, CAMA. A person under the age of 18 cannot form a company, right? If a person under the age of 18 is going to form a company, there must be another person in addition to this person who is above 18. So let me give you an example. Joshua is 17. Nick is 16. They want to incorporate a company. The principle is that they cannot incorporate the company because they are not of full age. But Joshua is 17. Nick is 21. Bayo is 22. They can incorporate that company because in addition to the person who is not of age, there are other people who are of full age. A person of unsound mind cannot incorporate a company. That is a person who does not have, just unsound mind is the word. An undischarged bankrupt cannot incorporate a company. A corporate body in liquidation, if another company is in liquidation, it cannot join as a member of a company. A person who has acted fraudulently in managing a company is precluded from joining a company. So these are the persons. Now you can be asked, mention 5 people who cannot join a company. A disqualified, a person below the age of 18, where there are no other persons above 18, a person of unsound mind, an undischarged bankrupt, a corporate body in liquidation, a person who has acted fraudulently in managing a company. Now, the promoters of a company have to engage the services of a certified professional in incorporating a company. Who are the certified professionals that can incorporate a company? 1, a chartered accountant. 2, a chartered secretary. 3, a legal practitioner. The professional must first file with the Corporate Affairs Commission the appropriate forms. There are something called CAC forms. So you must first file CAC form 1 for reservation of name. After doing this, the Corporate Affairs Commission, CAC, will reserve the name for 60 days. So, what are the documents required for incorporating a company? Please listen carefully. 1, memorandum and articles of association, stamped by the Commissioner of Stamp Duties. So, now, just simple, stamped memorandum and articles of association. That's 1. The memorandum and articles of association are like the constitution of a company. That's all the rules, regulations, and guidelines that affect a company are stated in this document called Memorandum and Articles of Association. 2, return of allotment of share form stamped by the Commissioner of Stamp Duties. Right? There's something called return of allotment form. 3, particulars of directors with their consent to be directors. 4, statement of share capital. I don't think I need to go into that because we have dealt with that. 5, statutory declaration by a lawyer. 6, any other document that CAC may require. These are what is required. Afterwards, the professional will present the copies of the documents and the forms, and we file the documents with CAC on payment of the prescribed filing fees. Upon doing this, CAC would grant the certificate of a company. Now, we'll go into capacity of persons who can incorporate a company. We have dealt with this in passing, but I'll just state it for emphasis sake. Now, there are some particular categories of persons who are prohibited from incorporating a company. In fact, I expect you to just say it along with me as I'm saying it now, because we just said it a couple of minutes ago. A person who is less than 18 years, where there are no other persons above 18. A person of unsound mind, an undischarged bankrupt, a corporate body in liquidation, a person who has been disqualified from managing the affairs of the company or from being a director of the company. These are the 5 people who do not have the capacity to incorporate a company. We move on quickly to membership of a company. We move on to membership of a company. Now, a member of a company has a right to, first of all, must define who a member of a company is. A member of a company is a person who, 1, has subscribed to the memorandum of the company. 2, or has agreed in writing to become a member of a company and whose name is on the register of members of the company. Please note, a person who has subscribed to the memorandum of a company or who has agreed in writing to be a member of the company and whose name is in the register of members of the company is a member rather. Now let me give an example. Joshua Nigeria Limited. Joshua Nigeria Limited has a memorandum where Joshua and Bayo subscribed to, and their name is entered into the register of members. They are called the members of Joshua Nigeria Limited, where Jide and Taiwo indicate interest in becoming members and subscribe to the shares, and their name is afterwards included in the register of members. They are also members. Now, what are the rights of the members of a company? A member of a company has a right to share in the profit of a company. 2, a member of a company has a right to attend and vote at the meetings of a company. 3, a member of a company has the right to share in the surplus assets, if any, of a company. So, a member of a company has the right to attend and vote at meetings, to share in the profit of a company, to share in the surplus assets of a company. What are the liabilities of the members of a company? The liabilities of the members of a company include 1, to contribute the balance, if any, in the amounts unpaid on shares. Let me just put it in simple language. The rights of the members: vote, attend meetings, share profit, share surplus assets. Liabilities: pay up on called up shares, or another way, pay up on paid shares. When you subscribe to the shares of a company, one does not necessarily pay up on the amount called, right? When you on the amount subscribed, when you subscribe to the shares of a company, you don't necessarily pay up on the subscribed shares. You are only to pay up 25%. You're only mandated to pay up at least 25%. You can choose not to pay up the remaining. Where the company calls up on its unpaid shares, you have a liability to pay up. Now, let me break it down with figures. Joshua subscribed to 1,000 shares of GT. Joshua is only mandated to pay up 25% at the point of subscription. So assuming Joshua paid for 500 out of the 1,000 subscribed shares, Joshua has paid up 50%. At any time, GT can say, come and pay up your remaining 50%. Joshua has a liability to pay up the remaining 50%. So that's it. To pay up on unpaid shares. 2, to pay when a company is being wound up to the extent of its liability. To pay up when a company is being wound up to the extent of its liability. So we move on. Who is a promoter of a company? A promoter of a company is a person who takes part in the incorporation of a company. 1, sets the company going. 2, and takes unnecessary steps to accomplish the purpose of the company. Listen, a promoter of a company is a person who takes part in the incorporation of a company. 2, sets the company going. 3, takes unnecessary steps in accomplishing the purpose or objects of the company. A promoter of a company is a person who takes part in the incorporation of a company. 2, sets the company going. 3, undertakes in accomplishing or takes necessary steps in accomplishing the purpose or objects of that company. So, by this definition, a wide range of persons can be termed as promoters. 1, a person who arranges for another to become a director of a company can be termed a promoter. So, a person who places shares in a company at the point of incorporation can be termed a promoter of a company. A person who negotiates preliminary agreements can be termed a promoter of a company. An entrepreneur who sells his business to a new company can be termed a promoter of a company. So, what are the duties of a promoter? 1, a promoter has a duty to act in utmost good faith to the company. Now, what do we mean? A promoter is there before the company is incorporated. A promoter is there before the company is incorporated. And so, deals on behalf of the company before its incorporation. Hence, a promoter do we understand? So the mother has a position or occupies a position of trust and must deal in utmost good faith for the child. The same applies to a promoter of a company and the company. Because a promoter is placed in a position where he can easily take advantage of the company, the promoter must has a duty of utmost good faith to the company. 2, a promoter has a duty of disclosure to the directors of the company and the potential members of the company or the members of the company when the company exists. That is, he must fully disclose what and all he has done as it regards to the company. So, 2 duties: 1, duty of utmost good faith, and 2, duty of disclosure. Now, in the event that the promoter breaches these duties, what are the remedies open to the company? The first remedy open to the company is the remedy of rescission. What does rescission mean? To rescind. What does to rescind means? To cancel. Where a promoter breaches his duty of either full disclosure or almost good faith, a company can, one, rescind the contract that it has with the promoter. Two, rescind any pre-incorporation contract that the promoter has entered into. Another remedy for the company is to call the promoter to account for profit. That is, every profit the promoter has made is to account for it before the directors of the company. And three, the promoters of the company can be sued for damages. Now, remuneration of promoters. A promoter ought not, or is ordinarily not, or rather does not ordinarily charge remuneration, right? A promoter does not ordinarily charge remuneration except there is a valid contract entitling him to do so. A promoter is not entitled to recover any remuneration unless there is a valid contract entitling him to do so. What does this mean? A promoter does not ordinarily charge for his services. Good. Let me put it this way. A promoter does not, as of right, charge remuneration. A promoter does not, as of right, charge remuneration unless and except a contract permits him to do so. That's it. That's it. We'll quickly move on to the organogram of a company, the organs of a company. The organs of a company. Mind you, remember a company is a separate legal personality. However, there are some organs through which a company works. One, the first organ is the general meeting of a company. This is the primary organ of a company. Right? It is the ultimate regulatory procedure of a company, the general meeting of a company. The second is the board of directors of a company. Every company must have its directors, and the directors are like the hands of a company. A company exercises its powers through its directors, and particularly through its boards of directors. The board of directors subdelegates their powers to the managing director. So it manages the affairs of the company for and on behalf of the company and the other directors. The managing director is the third organ of the company. The managing director is appointed by one of the directors appointed by the remainder directors, who subdelegates the directorship of the company to him or her. In performing his or her duties, the managing director is to conform to any regulations that may be made by the directors. The fourth organ of a company is the secretary of a company. The secretary of a company is charged with administrative duties. The secretary is not charged with managerial duties, but with administrative duties. And CAMA 2020 provides that every company shall have a secretary. So the duties of a secretary includes attending meetings, maintaining register and other records of the company, rendering proper returns and what have you. Please, it is not the traditional secretary we have in mind. A secretary of a company can be a company itself. A company can appoint another company to act as a secretary, which is usually the case for big companies. In appointing a secretary, directors of a company shall ensure that the person has requisite knowledge and experience, and only the following persons can be appointed as a secretary. 1, a chartered secretary and administrator. 2, a legal practitioner. 3, a member of the body of accounts. 4, any person who has been a secretary of a public company for at least 3 years out of the preceding 5 years. And 5, a body corporate whose members are qualified to act as a secretary. So 1, a chartered secretary. 2, a member of the body of accounts. 3, a legal practitioner. 4, a person who has been a secretary of a public company for 3 years out of preceding 5 years. And 5, a body corporate whose members are qualified under 1 to 4. We go to meetings. I hope we are following and listening attentively. We quickly go to meeting. We quickly go to meetings. So there are 4 kinds of meetings. 1, there's the general meeting. 2, there are statutory meetings. 3, there's class meeting. And 4, there is board meeting. General meetings are meetings by which the members exercise control and direction over the management of the company. Right? So there are types of general meeting. That's why we want to quickly go to types of general meeting. Annual general meeting. 2, extraordinary general meeting, AGM and EGM. Annual general meeting must be held every year, right? It must be held, as the name implies, it must be held in each year of the incorporation of a company. And not more than 15 months shall elapse between the date of one general meeting to the other general meeting. A newly incorporated company needs not have its annual general meeting in its first year of incorporation, insofar as it has it within 18 months of incorporation. Now, the board of directors shall convene an extraordinary general meeting as it deems fit, and not less than 1/10 of paid up capital of members of company holding up 1/10 of paid up capital of the company shall attend the meeting. Okay, let me get this clearly. For an extraordinary general meeting, the board of directors can convene it. Also, members of the company having 1/10 of paid up capital of the company can convene it, and the board of directors are mandated to convene it. Statutory meeting. A statutory meeting is for public companies, and they must hold it within 6 months of incorporation. Not doing so is an offense. Notice of meeting must be sent to every person entitled to having it. Who are those entitled to? The members of the company, the directors of the company, the auditors of the company, the secretary of the company, the representative of a deceased person, the receiver or trustee in bankruptcy of the company. And the meeting, the length of notice shall be 21 days from the date of the meeting or on which the notice was sent or more. So you should not send a notice of meeting when the meeting is next week, at least 21 days, right? But under special circumstances, a shorter notice may be given, and where members of the company accept it. Yes, so we move on quickly. Resolutions. Oh, Jesus. Resolutions. Now, the decisions of a company during its meetings are called resolutions. Resolutions are decisions taken by a company at its meetings. There are two types of resolution. There's ordinary resolution and there's special resolution. Ordinary resolution is a resolution passed by a simple majority of persons present at a general meeting. Ordinary resolution is simple majority, which is 2/3. Special resolution is 3/4 of the votes cast. What does this mean? Let us get it clearly. Where at a meeting, a resolution is passed by simple majority of persons, it is called ordinary resolution. Simple majority is 2/3, 2/3. Where the resolution is passed by 3/4 of the persons of the votes cast, of which 21 days notice have been given, it is called a special resolution. So that's that for meetings. We still have some way to go, so let us move quickly. We move on to company shares. So we'll quickly handle company shares and directors. So a share is the legal interest of a shareholder in the share capital of a company. Let me just break it down, please. A share is the unit of ownership of a member in the company, full stop. A share is the unit of ownership or legal interest of a shareholder in the company. Put it in clearly, a share is the unit of interest or ownership of a shareholder in a company. Don't let any other bogus definition confuse you. And that definition suffices for all purposes. Transfer of shares. Transfer of shares is the way by which a member of a company conveys his interest in the company to another person. Please. Transfer of shares is a voluntary conveyance of interest in the company from a person to the other. Is a voluntary conveyance of interest or shares in the company from one person to the other. It is effected by an instrument of transfer which must be in writing. And then the name of the, so for transfer of shares, there's transferee, there's transferor. Who is transferor? The person that transfers. Who is transferee? The person that receives. And the transferee must be, his name must be reflected in the register of members and register of shareholders. Trust transmission of shares. It is the conveyance of shares involuntarily or by operation of the law. Do you understand? So transfer is voluntary, transmission is involuntary. Where the person dies, where by operation of the law compels an individual to convey shares, then it becomes transmission and not transfer. We still have some way to go, so we must move on. Now, there are different classes of shares. There are preference shares. As the name implies, these shareholders have preference above all other shareholders, especially priority for payment of dividends. There's ordinary shares. These persons have priority over others aside from preference shares. There's deferred shares. These persons have priority. These persons do not have priority over preferred and ordinary shares and can only take dividends after the preference and ordinary shareholders have taken their dividend. And there's redeemable preference shares. So we quickly move on to share capital of a company. There's the nominal or authorized share capital. This is the share capital in which the company is registered in. There's the issued share capital. Right? This is the share capital that is issued to the public. There's the paid up share capital. I explained this before. This is the share capital that is paid up. There's a called up share capital. This is the capital that is called up by the company to be paid up by the shareholders. Now we move on to what are the directors of a company. A directors of a company are simply regarded to as the managers and executives of a company. They are the managers and executives of a company. They have control over the company, subject to the ultimate authority of the shareholders in the general meeting. They run the company day to day. They are in charge of the daily runnings of the company. Now, a company due to CAMA 2020 can have just one director. Must note that. And the first directors are the directors that are subscribed to in the memorandum of association of the company. Now, subsequent appointment of directors shall be done by the members of the company at its annual general meeting. The board of directors have the power to appoint new directors to fill any casual vacancy arising from death of a director. Now, some persons are disqualified from being a director. A person under the age of 18 is disqualified. A lunatic is disqualified. A person of unsound mind is disqualified. An insolvent person is disqualified. Now, removal of directors. Sorry. Yes, please note that there is a procedure for removal of a director. So let us note that, please. That a company can, by ordinary resolution, remove a director. However, a special notice must be sent to the director, indicating that at a meeting, he is to be removed and is to make a representation in writing. During the meeting, his representation is to be read out, after which the voting as to whether or not the director is to be removed is to be taken. So at the meeting, it is to be taken on whether or not the director is to be removed. A director can be removed by ordinary resolution, right? So a special notice is to be forwarded to the director on the fact that he is to be removed, right, by ordinary resolution. The simple thing is, what is the procedure for the removal of a director? In 1 minute, I'll state it. Please listen carefully. A director can be removed by ordinary resolution. Ordinary resolution is two-third, right? A notice is to be sent to him, informing him that at the meeting is to be removed and is to make representation. During the meeting, his representation is to be read out, after which the decision on whether or not is to be removed is to be taken. Simple. Remuneration of a director. Remuneration of a director. Now, the remuneration of a director shall be determined by the company in general meeting and is deemed to accrue from day to day. All traveling expenses are also to be paid to the director. The remuneration of the managing director, on the other hand, is to be determined by the directors of the company. Now, what are the duties of the directors? Now, the duties of the director of a company are of two kinds. One, the common law duty of care, skill, and diligence. And two, the fiduciary duty. Now, a director has the duty of care, skill, and diligence. That is, it must have the reasonable, it must exhibit the reasonable care, exhibit the reasonable skill, and exhibit the reasonable diligence required of a director, not of an ordinary person. No, of a director. And three, he has a fiduciary duty to the company. Now, the fiduciary duty falls under several heads. One, he has a duty of utmost good faith, is to deal with the company in utmost good faith. Two, is to act in the best interest of the company at all times. Three, is not to exercise the power of a director to preserve his office or to preserve himself, but for purposes of the collective good of the company and not for personal or collateral purposes. Three, is not to fetter his discretion or to contract on how he's going to exercise his discretion, right? Is not to collude, yes, is not to collude in exercising discretion. And five, the director is to avoid conflict of interest and conflict of duty. You have spent too much time on this. You must move quickly to hire purchase. Quickly move on to, I think we should take partnership before we take hire purchase. We still have a little bit of ground to cover. If you have some ground to cover, you must really Expedite. Yes. So we quickly move on to financial statement. The financial statement is a periodic report of the summary of the financial condition of a company. The company must keep its accounting records, which must be kept from day to day. The accounting records must be kept in proper format and must be kept in the company's registered office. A company must file its annual returns 42 days after its annual general meeting. Winding up of a company. Now, as how a company can be birthed by incorporation, a company can die by winding up. So winding up is the process by which a company dies or the life of a company is ended. There are three types of winding up. Voluntary winding up. As it implies, voluntary winding up is where the company decides to wind up by itself. 2, winding up by court is where the court actively winds up a company. 3, winding up subject to supervision of the court is where the court supervises the winding up process of the company. Now, the Federal High Court is the court that can wind up a company pursuant to provisions of CAMA. Who can petition for winding up? 1, an official receiver. 3, a contributory, a trustee, or the Corporate Affairs Commission. Now, what are the grounds for the winding up by the court? If the company passes a special resolution that it be wound up, default in delivering statutory report of a PLC, if the company is unable to pay its debt, then the company can be wound up. What's the procedure for winding up of a company? After the resolution, then a copy is forwarded to a Corporate Affairs Commission and a petition is filed in court. A company can itself decide to wind up its operations when the period fixed for the duration of the company expires. Yes, so a company can decide to voluntarily wind up. Notice of such resolution to voluntarily wind up must be advertised in the Federal Government Gazette or 2 national newspapers. And a meeting will be convened. So there are 2 types of voluntary winding up: members voluntary winding up and creditors voluntary winding up. Now we will move on to winding up subject to supervision of the court. So after a resolution for voluntary winding up, right, the court may, on petition, decide to supervise or permit that the winding up proceeds subject to the supervision of the court. Now, you must note some terms in winding up. Who is a liquidator? A liquidator is a person appointed to carry out the winding up process of a company. I'm going to go a little bit technical. I want you to listen carefully. A liquidator liquidates a company. It goes into the assets of the company, determines it, realizes the assets, pays the debt, and kills the company. That's a liquidator. An official receiver, who is the Deputy Chief Registrar, the DCR of the Federal High Court, or any officer, receives the assets of the company for payment of his debt. An official receiver sometimes does not kill the company, but only receives the assets to pay the debt. A contributor is every person liable to contribute to the assets of the company when the company is being wound up. And a compulsory winding up is when the company is being wound up by the court or wind up subject to the court supervision. So that is that for winding up. We move on to charges. A charge is an encumbrance on any asset, granting the holder certain right over the asset. What do we mean? A charge is a right over an asset. If I have a charge over this property, it means I have a right over this property. And this property is encumbered, meaning this property is answerable to me in a way. This property is chargeable to me in a way. This property is subject to me in a way. The most common form of a charge is legal mortgage. It is used to secure indebtedness of. It's used to secure indebtedness. Now, what is a fixed charge? A fixed charge is a charge given to a particular item, a specific asset. A company wants to borrow money. The company has a building, number 1, Women's Road, Ikoyi. If they collateralize that property specifically, a fixed charge has been granted over that property. Fixed charges rank in order of priority in liquidation. A fixed charge is a form of protection given to creditors relating to a specific asset of a company. A floating charge is a charge given relating to a class of assets. That is, if I give a loan and the charge is over the wristwatches or over the wares, yes, over the wares to be sold, that is a floating charge. So much for charge. We move on to insurance. Insurance is a contractual relationship which exists, please. Under the definition of insurance, you will get all the principles of an insurance. Insurance is a contractual relationship which exists between a person known as an insurer who undertakes to indemnify another person known as an insured for a loss upon a consideration known as premium to be furnished by the insured. So it's a contractual relationship between the insurer and the insured, where the insurer undertakes to indemnify the insured against any loss, and the insured undertakes to pay consideration known as premium. So yes, that's the definition of an insurance. Now, formalities of insurance: offer, acceptance, invitation. Please, let's listen. Now, there are some things that elements of a valid contract, they also apply to an insurance contract. These elements include offer, acceptance, capacity, intention to create legal relations, and consideration. Offer, capacity, intention to create legal relation, and consideration. Offer, capacity, intention to create legal relation, and capacity. So those are the formalities of an insurance contract. Now, in practice, who makes the offer? When the proposed insured submits the proposal form, right? The company will have a form. So when you go and collect the form, fill it and submit it, you have made the offer. When the insurance company receives your form and assent to your form, right? They have accepted. Now, an insurance contract is a contract of utmost good faith. It's a contract of ubimae fidei. So there are some facts that must be disclosed for an insurance contract. One, any fact which relates to the character and or habits of the insured. Now, say for example, um, the insured wants to insure a car. Say for example, the insured wants to insure a car, and the car is such that it has engine problem. One, that is a fact that increases the risk. Two, you stay beside the filling station, right? This is a fact that also increases the risk, right? And three, you go on long journeys and the car can be stolen. That's another fact that increases the risk. So in these circumstances, the risk is increased is a fact that must be disclosed. The real motive, which is that the car can be stolen, must be disclosed. Whether you have any other policy of insurance, yes, must be disclosed, right? Facts to which in your knowledge are material must be disclosed. So these are what facts must be disclosed. Now, some facts which may not be disclosed by the insured are: one, facts that are not known to the insured. Two, facts which can diminish the risks. Facts which are not known, facts which can diminish the risks. Facts which are waived, which non-disclosure are waived by the insurer. And facts contrary to public policy. Parties to an insurance contract. The parties to an insurance contract include the insurer and the insured. They include the insurer and the insured. Who is the insurer? The insurer is the insurance company. And who is the insured? The insured is the person taking on the insurance policy. Now, characteristics of an insurance contract. An insurance contract is a legally enforceable agreement. An insurance contract is subject to the occurrence of specified future events. An insurance contract is generally a contract of indemnity. It's generally a contract of indemnity. We should be done with insurance now. We should be done with insurance now. Before you can insure a thing, you must have an insurable interest in it. Now, what is the principle of insurable interest? It means that one, an insurable interest connotes that one will benefit from the continued existence of a thing or suffer from the loss of a thing. It means that one will benefit from the continued existence of a thing or suffer from the loss of a thing. So move on to the principle of subrogation. The principle of subrogation is to the effect that one is not allowed to profit from his own loss. One is not allowed to profit from his own loss. To the effect that in an insurance contract or where you invoke an insurance policy, you are only to be indemnified to the extent you would have been if you did not suffer the loss. For example, you bashed your car and you claim insurance. After claiming your insurance, you can't now go after the person and say, still pay me. No. Right? Because you would have benefited from your loss, having made profit from the third party and made profit from the insurance policy. What's the principle of indemnity? The principle of indemnity is that a person be restored to the position he would have been, assuming there was no loss. That's the simple principle. Now, what's the principle of double insurance and contribution? It means that a person can have more than one insurance policy over a particular insurance risk, but that whenever there is a loss, the insurers will contribute to mitigate or to indemnify the insured. Right? So that's the principle of double insurance and contribution. For this to happen, the risks must be common to both policies. That is, it must be either fire risks, loss risks. The insurance must cover the same subject matter. The policies must cover the same interest. Each policy must be enforceable at the time of loss, and the policy must not exclude contribution. We quickly move on to a contract of employment. A contract of employment is a voluntary agreement between a master and an employee, where the employee, for a money consideration, promises to render to the master services. Now, forms of a contract. Where a contract is written, a court will apply it strictly and give effect to the terms of a written contract. What are the duties of an employee? An employee has a duty: one, to obey lawful order; two, to exercise his professed skill and diligence; and three, to do the duty for which he was employed. 4, an employee also has a duty to render personal service and not to delegate the duty he ought to render under his contract. 5, to keep his employer's information confidential. 6, to serve his employer faithfully. And what are the remedies for breach of an employee duty? Sanction. 1, 2, suspension, and 3, an employee may be sued. An employer has a duty to provide work. An employee may be dismissed for any act or conduct likely to bring the employer into disrepute. May be dismissed for absenteeism, for gross misconduct, and what have you. A contract of employment can be terminated by natural events. It can be terminated by operation of the law. It can be terminated by mutual agreements between parties. We move on to partnership. What's a partnership? A partnership is an agreement between two or more persons to carry out profit with a view to make to carry out business with a view to make profit. Right? Is an agreement, whether oral or written, between two or more persons to carry out business with a view to make profit. A partnership is not a separate legal entity from its partners. How there's general partnership. In general partnership, all of the partners are involved in the management of the partner or of the partnership. Yes. Two, there's limited partnership. This is where one of the partners elects not to be involved in the management of the partnership and of his contribution. A limited partner also has a limit as to his liability to the partnership as indicated in the partnership agreement. A limited partner cannot bind the firm. He cannot contribute to the management of the firm. He cannot dissolve the firm. There's a partner by holding out. Yes, so a partnership business can decide to have a partnership agreement. And this partnership agreement can be by deed. This is called a partnership deed. So what is a partnership deed? A partnership deed is a partnership agreement made under seal. A partnership deed has the following: the name of partners, this is also the principle of partnership. Where a partner where an individual holds himself out as if he were a partner of a company, he will be liable as if he were a partner. Um, so we have one more. Partnership can be dissolved one, by agreement. Two, if the partnership is running at a loss and